I'm going to read mine as well, trying to keep to time. And contrary to what Claire's suggested for the title for my talk, which was Transfer of Title, New Guidance and Need, I've instead called it the Archive Conundrum. As the talk progresses, I hope you'll understand why I've called it this, and also how we might now have a way to unlock that conundrum. The recently published Toolkit for Managing Ownership of Archaeological Finds in England. So just to quickly provide some background for those of you who may not know FAME as a trade organisation, trade association, we represent archaeologists who engage in developer-funded work, and we seek to promote a business environment where archaeological organisations operate safely, sustainably, and for public benefit. There are 3 tiers of regulation that govern our members' work. The top tier, of course, is legislation. The second tier is policy, and the third is guidance. And guidance can come from national agencies, can come from CIFA, and it can come from other organisations. Much of the work we undertake generates an archive, which is comprised of site records and artifacts, and that's where the problems lie. This is where the conundrum occurs. In law, all artifacts come under property ownership and are therefore not available to archaeologists to gift to a museum without permission of the landowner. Policy and guidance, however, expect us to deposit an archive for public access, making no distinction between the site records we own and the artifacts we don't own. And for example, in Historic England's Good Practice Advice Note 2, Managing Significance of Decision Making, paragraph 39 says, local planning authorities are advised to ensure that the compilation, deposition, and appropriate conservation of the material, digital, and documentary archive in a museum or other publicly accessible repository willing and capable of preserving it forms an integral part of any recording project. The vast majority of archaeological investigation is undertaken as part of the planning process, often as a condition of planning permission, which is legally binding on the applicant, but not on the landowner, and a process in which museums have no obligation to take artifacts or an archive at all. So our legislative and policy frameworks have a disconnect at the core of what, as archaeologists, we wish to achieve. Just to give a sense of some of the complexities that can occur, which can destabilize this house of cards that we have built for an ideal archaeological outcome, here are a few examples or thoughts. Firstly, is a planning condition open to challenge? Can it be valid and legal if no repository exists, as it requires something that cannot be delivered? Secondly, applicants are very often not the landowner. So we need a system which identifies and explicitly draws the owner into the process. But also, do we manage the many evaluations which occur before any planning permission, so are not subject to a condition? And what if we have a site where the applicant has options from multiple landowners, for example, a house builder who has options on 13 different owned plots of land? How do we know who owns what artifacts we have found during the investigation? And will this ownership change before a planning condition is placed on the applicant, so that artifacts from the mitigation phase are owned separately from the evaluation phase? Even when we know who the landowner is, signing a transfer of title document can be too trivial for them. For example, a few sherds of Iron Age pottery from land owned by a global company in an area with no museum is just not important enough for a director, a property manager, a project lead, or others within the company to worry about. It's below their pay grade. And how do we, as archaeologists, put pressure on them, prioritize them, drill down into their management structure to find who has that authority to sign a transfer of title. As an alternative, we can try returning the artifacts to the owner. But even that can be difficult. I, for example, have a local council where the council-owned museum service will not accept artifacts from a site owned by their own council, as they need paying to take them. That's perfectly understandable. But this is an internal matter, and meanwhile, we're left having to store the retained archive of some 30 boxes. Life was much simpler in the 1970s and 80s, as those of you who were there might remember, when publication and archiving were first seen as problems. We had the Freer and Cunliffe reports to provide clear guidance and develop a 4-stage process. Post PPG 16, we benefited from further guidance on archiving during the 1990s and noughties as part of increasing professionalism. For example, the 1990 guidance for archive preparation and storage, the 1993 guidance on selection and retention, the 1995 Society of Museum Archaeologists towards an accessible archive, and the 2007 Archaeological Archives Forum best practice guidance. However, over the past 15 years, we have become overloaded with archive guidance. This is obviously my opinion, and possibly some others, leading to many practicing archaeologists becoming lost in the detail and losing focus of what is significant and proportional. Why do we need so much guidance on archiving when we only have one guidance document each for evaluation, excavation, and monitoring? It is disproportionate and at times lacking in pragmatism, proportionality, and in understanding the need for assessing significance. Perhaps all this wordage has been generated in an attempt to address the problems with archiving and the disconnect between planning process and museum capacity that were being identified by FAME and others. In 2010, we published an article highlighting the growth in archives that couldn't be deposited. 9,000 of them and 42,500 boxes of artifacts in the 2012 survey were identified, with 28 local authority areas and 40 museums lacking facilities to take them. By 2024, 20% of our museums were not collecting archaeological archives, and 46% of the others had less than 5 years capacity left. In 2014, Helen Parslow, on behalf of FAME and AAF, advocated for transfer of title to be made an explicit part of a phased planning condition. But to date, that has still not been seen as a responsibility for planners and their advisors to promote. This, in my opinion, has contributed to the growth of our problems with undeposited archives. Apart from the ongoing unfunded cost of storing these undepositable archives for FAME members, there are also the obvious risks. We are legally liable, as the artifacts do not belong to us. We're not curators and don't have environmentally sound museum conditions for storage or access for people, or often having access for people to come research them. And then there are also threats, such as theft, flood, and fire, all of which have occurred, destroying partial or total archives. Now, those are definitely ways to reduce the archive backlog, but not one of us would recommend it. In 2016, FAME issued a clear statement and call for action in which we said long-term storage by members was unacceptable, and that as these archives were generated by the planning process, LPAs, local planning authorities, must enforce archive deposition on applicants. We also suggested that to overcome the problem of museum capacity, a national solution was required. Historic England and CIFA agreed this was an issue that needed collective action. And through the 21st Century Challenges for Archaeology Initiative and the Future of Archaeological Archives panel, we have consulted with partners in the Society of Museum Archaeologists, Algeo, and others to find a way forward. Legal advice was sought by Historic England through a QC, which resulted in Duncan Brown drafting the Toolkit for Managing the Ownership of Archaeological Finds in England, which is now published for application and feedback. This is a very welcome document. Essentially, the toolkit is divided into two parts: a model deed of transfer for the landowner to sign at an early stage in the planning process, and a guidance document for a legal mechanism for artifacts held by archaeological organisations to be deposited with a museum or repository through a process called conversion, without the complicated process of tracking down who the owner is and getting them to sign a transfer of title. The deed of transfer is an 8-page legal document designed for the local planning authority to instruct the applicant or developer on the need for them to disclose who the landowner is, and then ask them to sign an in-principle agreement to transfer ownership of archaeological objects to the local planning authority's identified museum or repository. It includes a process for identifying any artifacts that are found, listing those that are to be retained and deposited, so that at the completion of assessment and analysis, the material archive can be legally transferred by the archaeologists unless the owner decides they wish to retain them. Crucially, the toolkit states that the deed of transfer should be introduced by the archaeological advisor to the planning authority as part of their consultation response to an application, whether for predetermination evaluation or as a condition on planning permission. The applicant is then obliged to get the landowner to sign the deed or to say that they wish to take their artifacts back and therefore maintain them and provide access to the public. The second part, what's called the tort of conversion, describes the process for legally asserting ownership over archaeological artifacts, so that material archives that have been stored for over 6 years without being claimed by the owner can be transferred to a museum. This is achieved by standard methods that archaeologists undertake, such as cleaning, cataloguing, and labelling finds, undertaking analysis, and repackaging artifacts. So the toolkit is immensely helpful in resolving our conundrum about the legal and policy disconnect in depositing the material archive. However, I have had a recent case study from a FAME member who's actually experimented with the new toolkit, with this idea of conversion, and tried to deposit 300 boxes from a site where the developer or the applicant had been dissolved, the company had been dissolved, and no landowner was known. The museum said that the principles of conversion did not accord with their own policies. And as it was out to consultation, the toolkit might change in any case. So they needed evidence of 3 attempts to contact the owner by tracked mail before they would accept the archive. So the toolkit, the deed of transfer, and the conversion process can only be successful if proactively implemented by those who have sufficient power to make developers follow due process, i.e. the planners and their archaeological advisors in the local planning authorities. I've got some questions up on the slide here, because this is what we need to know. Will local planning authorities adopt these solutions, engage with the applicants, and offer deed of contract for transfer of title? Will LPAs identify the specific local repository that collects archives as part of their because how can we deposit it if we don't know which that museum is? And if there are no museums in that area, how legal, how enforceable is their planning condition? And will local planning authorities enforce applicants to fulfill their planning obligations? The toolkit doesn't solve the problem of museum capacity, but local planning authorities will know whether they have museums that will collect in their areas. And so the LPAs are essential for communicating this to developers and landowners as part of the consultation planning process. FAME members can then fulfill their contractual obligations to their clients. Museums can feel secure in receiving legacy archives. The inappropriate long-term storage of archives by FAME members can be remedied. And, to coin a recent phrase, this can all be achieved by a coalition of the willing. Thank you.